And good afternoon, good evening, good morning from wherever you are joining. And today's webinar on access to remedy, the role of alternative dispute resolution in business and human rights agenda. On behalf of the Nigerian Institute of Arbitrators and our collaborating organizations, United Nations Human Rights Special Persons, United Nations Development Program, as well as International Law Association Nigeria branch, welcome you to today's webinar. My name is Shola Oshodi John. I'll be moderating today's section of the webinar. Please permit me to briefly introduce our president, Professor Fabian Ajogu, who is going to be delivering the opening remarks at the webinar, as well as Professor Damilola Olawuye, who will be presenting the keynote address and an exposition on the theme of today's webinar, access to remedy, the role of alternative dispute resolution, ADR in business and human rights agenda. Before I briefly introduce our keynote speaker, I would like to say that the webinar is going to go in this format. We'll have the opening remarks and thereon the keynote address. Proceeding after that, we will have panelists' comments on the keynote address, panel discussion, question and answers, and any other business, and then we'll bring the webinar to a close at about 5:05 p.m. Nigerian time. So I would like to, first of all, introduce the President and Chairman of the Nigerian Institute of Arbitrators, Professor Fabian Ajogu, Senior Advocate of Nigeria and a Professor of Corporate Governance at the Lagos Business School, and alumnus of both State Business School at Oxford University and Lagos Business School. He has a doctorate in law from the University of Aberdeen, an MBA from IC Business School, University of Navarra, and law degrees from the University of Nigeria and the University of Lagos. Professor Fabian Ajogu is the founder of the Society for Corporate Governance Nigeria and a fellow of the Nigerian Institute of Arbitrators. He is also associated with several prestigious organizations, including the African Leadership Initiative West Africa, Eric Crown Global Leadership of the Aspen Institute, the IFA Reading Society, Society for Art Collection, the Oxford Philosophical Society, the Royal Institute of Philosophy London, and the Royal African Society UK. Currently, he serves as the president of the Nigerian Institute of Arbitrators. His service includes positions on the Governing Council of the Pan-Atlantic University, the General Counsel of the Bar, and the Council of Legal Education Nigerian Law School. As the statutory designated distinguished legal author, he is a member of the International Council for Commercial Arbitration and the London Court of Arbitration, and so many other portfolios and arts that he does well. So I also have today with us Professor Damilola Olawuye, SAN, who will be giving us the keynote address. Professor Damilola Olawuye will be giving us the keynote address after Professor Ajogu. May I just, at this junction, request that please Professor Ajogu give us the opening remarks to declare the webinar open. Thank you.
Thank you very much to our Registrar and Chief Executive Officer of the Nigerian Institute of Chartered Arbitrators. I would crave your indulgence over the background noise that you hear. I'm in Lagos, Victoria Island, Lagos, and it's raining heavily. There is no way to put a soundproof in our normal building to filter out the sound of the rain. So please do bear with me if you hear a little more than my voice this afternoon. So I offer you a warm welcome to the webinar organized by our institute, the Nigerian Institute of Chartered Arbitrators, on the theme, access to remedy, the role of ADR in business and human rights agenda. This theme explores a significant role of alternative dispute resolution mechanisms in the way that we carry on business, as well as in human relations, particularly touching on labor-related matters and human rights issues. Now, but just to sort of set the stage, ADR in Nigeria has gone through different stages of evolution. And where we are with the passage of the Arbitration and Mediation Act of 2023 is a complete alignment with the arbitration and mediation framework that sort of is in consonance with international standards, learns from the gaps that the previous law has had, the framework, and of course, with the benefit of case law and corrections of the gaps we had in the previous law. So it is pleasing that we have very distinguished panelists and a keynote speaker in the person of Professor Damilola Olawi, a senior advocate of Nigeria. He's going to be talking about UN Working Group on Business and Human Rights, and he's a president of the International Law Association. We'll be talking on this theme. Our panelists have been carefully selected, and they will be introduced in due course. But the whole idea is to touch on addressing business-related disputes, particularly at the workplace, and to look at how effective arbitration and mediation can be in dealing with these issues, judging by all of the challenges that we've had in the past. Now, the Nigerian Institute of Chartered Arbitrators, as you may know, continues to lead in Nigeria and, of course, the West African region in promoting ADR in many ways. First of all, in building capacity, disseminating knowledge, and creating this kind of fora, physical and electronic, for practitioners and incoming practitioners to learn more about arbitration and mediation and new trends, changes in the law, challenges that are met, lessons from other jurisdictions that compare with ours, and of course, continually charting the way, including engaging with regulators and government on how to promote the facilitating role of courts as against the disruptive roles in terms of supporting arbitration, its recognition and enforcement in this jurisdiction. The Institute is partnered with civil law countries, the OHADA group, again, in driving and promoting the same thing. So I once again would like to commend Chief Executive Officer and the organizers of this webinar for finding it fit to put it together as one in a series of webinars designed to build capacity, disseminate knowledge, and of course, bring people together from across different countries, one in London, in Kenya, Nigeria, to talk about the access to remedy and the role of ADR in business and human rights. So I welcome you to the webinar and declare the webinar open. Please enjoy it and make it as interactive and as useful as possible. Thank you very much.
Thank you, Professor Ajogu SAN, President of the Nigerian Institute of Arbitrators, for setting the pace for today's webinar. We are most grateful. I would like to briefly read the profile of our keynote speaker for today, Professor Damilola S. Olawi SAN, before I call him to take the floor. Professor Olawi is a fellow of the Nigerian Institute of Chartered Arbitrators, the president of the International Law Association Nigerian branch, and he holds several prestigious positions, including UNESCO Chair on Environmental Law and Sustainable Development at Ahmad Ben Khalif University, Qatar. He is also the director of the Institute for Oil, Gas, Energy, Environment, and Sustainable Development at Afe Babalola University, Nigeria. Professor Olawi has authored numerous publications on energy, environment, and human rights law, with his book, environmental law in Arab states, receiving the 2023 ASIL Certificate of Merit. Professor Lawi has advised prominent organizations like the World Bank and the United Nations agencies, served on the African Commission on Human and People's Rights, and provides legal counsel at McNair International, Qatar. He has held key roles in the Nigerian Bar Association and Nigerian Extractive Industries Transparency Initiative. He holds degrees from Oxford, Harvard, University of Calgary, Canadian University, and the Nigerian Law School. Professor Lawi is the founding editor-in-chief, of the Journal of Sustainable Development Law and Policy, and also holds leadership roles in several international law and environmental law organizations. Professor Lawi will be delivering the keynote address on today's theme, Access to Remedy, the Role of Alternative Dispute Resolution in Business and Human Rights Agenda. Professor Lawi, you have the floor.
Thank you very much, our distinguished registrar and chief executive, for that very kind welcome. Our distinguished chairman and president of the Nigerian Institute of Chartered Arbitrators, Professor Fabian Ajogu, officer of the Federal Republic, senior advocate of Nigeria, and fellow of the Chartered Institute of Arbitrators, and so on and so forth. It's a great pleasure to be with you. Thank you for the opportunity. My lords, your excellencies, ladies and gentlemen, it's my pleasure to deliver the keynote today. But I see that our association, the ILA, is a partner for this event. So I think before I go into the keynote itself, I better say a few words about the ILA so that you can know who we are. So I'll put on that hat for now before I go into the keynote lecture. The ILA is proud to partner with NICAP for this event. As you may already know, the ILA was founded in 1873 in Brussels, and it has membership from across the world. The aim of the ILA is to study clarification and development of international law. And I like to say that unlike the IBA that is mainly for lawyers, the ILA is for lawyers and non-lawyers, so diplomats as well as arbitrators, engineers, anyone interested in international law is welcome to be a member of the ILA. And the Nigerian branch was established in 2014. It was launched by the Chief Justice of Nigeria. And since then, we have been advancing Nigeria's brand of international law. I would say that, like I mentioned, we welcome those in academia, government, non-lawyers, public and commercial industrial experts to join us. And I would like to highlight briefly that those interested in studying international law can join us for upcoming Certificate of Advanced Studies in International Law and Diplomacy. And you'll find more information about this on the ILA website. And feel free to follow us, join us in learning more about international law. Again, we thank the NICAP for partnering with us in this important endeavor today. So having given you the compliments and greetings from the ILA, I can now wear back my cap as the keynote speaker and as an independent expert of the United Nations that has been working on this issue of access to remedy for a while. I would say that NICAP has proven its worth as the leading ADR center in Nigeria by picking such a timely and important topic to be the focus of our discussion today. Access to remedy, the role of ADR in the business and human rights agenda. Briefly, I will give you an overview of our work in the United Nations Working Group on Business and Human Rights. I'll talk about the sources of corporate harm, and of course, I'll provide some reflection on the roles that we think that ADR can play, especially arbitration. As a starting point, I should mention that before now, when you talk of international law, of course, we understand international law to be the law of nations. So before now, anytime there was a talk about international law, the focus used to be excessively on states, what governments should have done better, how governments should have acted better in protecting human rights and the likes. But over the last few years, it became obvious at the UN level that there is a need to shed some light on what businesses can do, especially given that some businesses have budgets that are even more than the revenue and annual budgets of some countries. In our work in the UN, for example, we're in a country last year, an African country, and we discovered that there was a business operating there that they've become so powerful that they decide who is going to become the next head of state of that country. So it became clear to us that focusing on government alone will not solve some of the pressing challenges facing the world. So it became crystal clear that there was a need to shed light and look and put the microscope closely on what some of the large corporations are doing. And this led to the whole idea of business and human rights, the responsibility of businesses to respect, to protect, and to ensure that they fulfill human rights mandates across the entire sphere of their operations. And again, while we recognize that businesses can be a force for good, it is not all businesses that violate human rights, so to say. But we've seen in many countries how business enterprises have been responsible for damage to land, to water, to environment. Some of the images there may be very familiar to those that follow the discussions in the Niger Delta region of Nigeria, for example, and how some of the activities there may have been affecting human rights over the last several decades. We've also seen concerns about workers' rights, use of forced labor, preventing collective bargaining, unfair pay practices by some large businesses. And recently, we've seen concerns about greenwashing and misleading claims, how businesses claim to be sustainable, but then you find the reverse. We saw a major oil company being sued recently for saying that their product is climate neutral, but it turned out not to be. So some of these concerns led the United Nations to appoint a special rapporteur to look into this issue. And the end result, there's a long story behind it. The end result was that by 2011, they had adopted a document called the United Nations Guiding Principle on Business and Human Rights. And that's the document right there. The United Nations Guiding Principles on Business and Human Rights, the draft was initially prepared by Professor John Ruggie of Harvard University, but then it was adopted by the UN Human Rights Council, and it became the authoritative document on what responsible businesses should do to protect human rights. It also contains recommendations on what states, as well as other stakeholders, should do. And if you've not seen this document, it's available online. Feel free to download it. It applies to all states, applies to all companies, irrespective of the size, irrespective of the sector. It does not really create new legal obligations. It just sort of crystallizes some of the core human rights obligations in core international treaties that have existed for many years, whether you're talking about the International Covenant on Civil and Political Rights or all others, the CEDAW and the rest. So this document sort of draws from them and just puts everything in one document as what responsible states should do. It emphasizes the need for smart mix, so focus on legislation, as well as focus on practical aspects, so a mix of regulatory and voluntary approaches. And it sets a number of baseline responsibilities for all actors. One of the key things that I must of course, highlight is that this document, again, in 2011, then established our working group. It established the working group on business and human rights to monitor the implementation and dissemination of this document across the world. And our working group is made up of 5 independent experts drawn from different regions. And I sit in the working group as the member from African states. So in that capacity, we go from country to country, trying to understand what states and businesses are doing to advance this important document. And of course, I can say more about our activities, but in the interest of time, of course, I wouldn't go into too much detail. Our activities include conducting country visits. We do 2 country visits a year, in addition to other academic visits that we undertake. Last year we were in Argentina, we were in Japan. This year we will be in Colombia. as part of our mandates. And of course, we also organize events and activities to promote these norms, such as this important event that we're having today. So 18 country visits we've had so far, 1,100 communications meaning reports from anyone saying, look at what this business is doing. And then we consider such reports. And when it is necessary, we issue statements to condemn such activities or to say whatever we need to say. 30 reports that we've published, all available on our website, 12 annual forums in Geneva every year. We're preparing for the 13th edition later this year, and we welcome you to join us in Geneva last week of November to talk about business and human rights. Now, having said that, I should just say, as part of my keynote, that there are 3 pillars of the UNGPs. So the duty of the state to protect human rights by providing legislation, providing national action plans, and clarifying what businesses should do. The second pillar is the responsibility of the business itself to respect such norms. So the state has legislated or provided guidelines. The responsibility of businesses worldwide to respect such norms is the second pillar. The third pillar is the access to remedy pillar. And that's the one that we're concerned about today, which is how can we ensure that whenever there is a wrong, there is indeed a remedy. Whenever someone is saying that this business has done this or has violated my rights, how can we give them fair, timely, and transparent access to remedy in a manner that fulfills international human rights norms? So, of course, because today we are focusing on access to remedy, I'll go straight to access to remedy. It is the obligation of states, as well as all actors, businesses as well, to provide a remedy whenever there is concern about human rights abuse. So taking appropriate steps either through judicial, administrative, legislative, or other means to ensure that those affected by irresponsible business practices have access to effective remedy. Now, in our consideration and under the UNGPs, we have different methods of providing remedy. There is a state-based judicial mechanism, which will include courts, of course, litigation and the likes. But the one that concerns us today is the non-state-based grievance mechanism. That is, it is non-state-based, so it's more of voluntary by stakeholders who wish to engage with other mechanisms outside of courts to address these concerns that they may have based on what a business has done. And the UNGPs recognize the important roles of arbitration, mediation, and conciliation to provide non-state-based judicial mechanisms to redress human rights abuse. Now, in celebrating 10 years of the guiding principles, we took stock to say what can be done to ensure or enhance the use of ADR, as well as other mechanisms to promote access to remedy. And in order to, I'll give you some of those key points as the take home on the roles that we feel ADR can play. And some of these recommendations are also in our very recent reports beyond just this document that is online, and you can download this particular one. But in our report, for example, the report that I presented to the UN General Assembly in New York last year, we did mention the important role of ADR, the need to integrate ADR mechanisms, especially arbitration, into national action plans on business and human rights, into legislation in order to foster access to remedy. One key point here is that we noticed that in many countries, what hinders the role of arbitration is that the law often says arbitration applies to only commercial disputes. So that is a big problem, because if I'm complaining that my land has been polluted, it may not be a commercial dispute. So that is a key gap in legislation that we found in many countries. They need to expand the scope of legislation to not just focus on commercial disputes. And of course, I know that some of our speakers will tell us, especially I see that Tolu Aderemi is here, who is an expert in business and in arbitration. He will be able to tell us whether the new law, whether the new Arbitration and Mediation Act has addressed this gap or not. But it's a gap we've seen in many countries. A second issue that we often highlight is the need for clarity. There is a need for clear and specific rules that will guide the use of arbitration, especially when you are talking about human rights disputes and things like that that are not commercial. So, of course, some of the experts have come together to propose the Hague rules on business and human rights arbitration. And I know that Claudia, who is one of the leading experts that worked on these rules, is here as a panelist. So she will be able to tell us whether the Hague rules can indeed guide us on how to apply arbitration in the business and human rights context. There is the issue of legitimacy and effectiveness as well. If we're going to use arbitration and ADR to address business and human rights disputes, several of which may not be commercial, then we want to ask, how can we ensure that there is transparency, there's legitimacy, there's effectiveness? As we say, the best way to know whether an access to remedy mechanism or a grievance mechanism works is to ask the stakeholders themselves, are they satisfied? If they are satisfied, then they will want to use it more. So how can we ensure that stakeholders, farmers, villagers, those impacted by business activities will have full confidence in arbitration as the go-to mechanism rather than going to courts all the time? Again, I see that one of the panelists, Florence Shako from Kenya, she has experience in this area. From our practice, she will address this question. So my role is very simple, to set out the issues while I leave it to the experts to inform us. Of course, the last point I would like to make is the need to promote education and awareness on ADR. There is a need to address some of the lack of awareness or knowledge on ADR generally, especially arbitration. For us in Lagos and Abuja, in the big cities, we talk about arbitration and conciliation, but when you talk about BHR, it goes beyond the big cities. Do people in Abeokuta, in Aba, and in Kotangora, do they know about arbitration? So there is indeed a need for NICAB, ILA, and other key stakeholders to promote more awareness. And this is not just awareness targeted at lawyers, awareness on ADR to CSOs, to academia, to business enterprises. And I know that Oyeni Abe, who chairs the Business and Human Rights Committee of the ILA, is here. He might be able to tell us what the ILA is doing in this regard. We are very optimistic at the UN that arbitration and ADR has key roles to play in addressing several of the problems that facing our world, especially when it comes to irresponsible business practices. And I think I should end by commending NICAB for taking the lead in this area. And we look forward to concerted success, and we look forward to supporting your efforts going forward. I thank you very much.
Thank you, Professor Damilola Alawi, for really hitting the nail on the head. I just want to draw out like 5 points, key points that you had highlighted in your keynote address that I believe the panelists that are online will want to throw light on, say a few words on them. First of all, you did say, I agree with that, where there is a wrong, there is indeed a remedy, 100% correct. And that is why we are here today. The question that I have was, that you mentioned, was the role of arbitration and the role of arbitration, and why arbitration only seemingly applies only to commercial disputes, and there's no laws, probably Nigeria and probably other countries, that expands the scope of ADR in addressing disputes between other disputants. And then the second point that you raised was the need to expand the scope of ADR in the law to include all that types of disputes. And the third point was lack of clarity in guiding the use of arbitration, the issues of legitimacy and effectiveness. And then you raised the issue of how do we ensure transparency and due process, access, and legitimacy, among others. Then fifthly, you said there's a need to promote education and awareness in ADR. So please, we'll just hold on to those 5 points and permit me to introduce the panelists that would shed some light on Professor Alawi's keynote address, and probably raise some more points for us to look at during this webinar. I would like to first of all introduce the number one panelist today, Claudia Naka. She's an independent arbitrator and counsel specializing in international arbitration and public international law, in particular investor-state disputes, interstate disputes, disputes involving international organizations, and human rights cases. Prior to January 2024, Claudia was a partner at Descartes and prior to a partner at Clary Gottlieb, where she represented sovereign and private parties in more than 35 investment arbitrations, interstate and commercial arbitrations, and before the European Court of Human Rights. Claudia has served as an arbitrator in investment treaty and commercial arbitrations. She is a member of ECIT, panel of the arbitrators, and serves on the SEAC Court of Arbitration and VAC board. She holds a PhD. She holds a PhD in public international law from the University of Vienna. She's an adjunct professor at the University of Vienna, where she teaches advanced research seminars in public international law and supervises PhD theses. She also regularly lectures at other leading universities. Claudia is someone that I've been following a work regarding the age rules on business and human rights and arbitration. And Claudia today is going to be telling us a lot about the egg rules and also responding to some of the key points that Professor Olawi has raised. Claudia, you have the floor.
Thank you very much for your kind introduction. Up until now, I think it's fair to say that arbitration has had a quite limited role in resolving human rights disputes, and specifically looking at the 2019 Hague Rules on business and human rights arbitration. A version of the anti-trial rules specifically tailored to the resolution of business human rights disputes. Those rules have not yet been used. In principle, arbitration could offer important advantages in resolving business human rights disputes. First and foremost, of course, arbitration provides a neutral forum. The parties may appoint arbitrators with special expertise in both business and human rights law. And arbitration can also overcome the jurisdictional hurdles that victims of human rights violations often face in domestic court proceedings, as well as in enforcing ensuing court judgments. Now, arbitral awards settling business human rights disputes are in principle enforceable in more than 170 states under the New York Convention. Although, as mentioned before, there may be certain questions in about 50 states, contracting states to the New York Convention, that have made a reservation according to which the convention shall only apply to commercial matters. But I would interject that we had a similar discussion in the context of investment treaty arbitration. Also, arbitrations adjudicating disputes involving public interests. And in that context, it was clarified that investment treaty disputes do qualify as commercial matters for purposes of the New York Convention. So one could think of similar solutions also in the context of business human rights disputes. Now, why has arbitration so far been neglected as a remedy for business human rights violations? I think there are two principal reasons. The first is that arbitration requires, of course, consent by both parties, consent by companies to submit human rights disputes to arbitration. Now, there's often no pre-existing contractual relationship between victims of human rights violations and businesses, and it is quite rare for parties to agree to arbitrate after a dispute has already arisen. So in finding solutions to make arbitration and ADR more generally more practical, it will be critical to secure consent of potential respondents before a dispute has arisen. Our second, costs. And the costs associated with pursuing an arbitration and the knowledge required to conduct arbitral proceedings may also currently constrain a resort to arbitration to resolve business human rights claims. We can learn some lessons from the only two known business human rights arbitrations. In 2016, two global labor unions initiated arbitrations, ancillary arbitrations, against two leading fashion brands. They did so under the Accord on Fire and Building Safety in Bangladesh. An accord concluded in 2013 between more than 200 global fashion brands, retailers, and labor unions to improve human rights standards and work safety in the Bangladeshi garment industry. The accord was prompted by the tragic collapse of the Rana Plaza building in Dhaka, which resulted in the death of more than 1,000 people. In those arbitrations, the victims did not need to pursue their claims themselves. They were represented by labor unions, and the labor unions in turn were represented by a US law firm on a pro bono basis. Pursuant to the applicable ancillary rules, hearings were to be held in camera, and the award was to be kept confidential unless all parties would agree to its publication. The identity of the two defendant companies and their counsel remain confidential until today. The Hague rules on business and human rights arbitration, by contrast, require transparency. That was a deliberate choice from a public interest perspective and also as a potential deterrent against future human rights violations. But transparency may also act as a disincentive for companies to agree to arbitrate human rights claims, given the reputational damage associated with such claims and the media coverage that such claims often attract. Transparency may incentivize companies to actively participate in the resolution of business human rights disputes, but it would rather be where their failure to do so may entail negative publicity and potentially other adverse consequences. It is interesting to look at the practice of the OECD national contact points for responsible business conduct. In this context, those national contact points are tasked with the implementation of the OECD guidelines for multinational enterprises. There are currently OECD national contact points in 51 states, which offer mediation and conciliation services. Now, no party is required to agree to mediation or conciliation, so it is a voluntary process, but many companies against which a complaint is lodged actually do actively engage in the process to try to reach a settlement. Now, an important factor that likely incentivizes companies to do so is that the national contact points make their conclusions as to compliance with the OECD guidelines and their recommendations public, whether or not the company concerned chooses to participate in the process. And the conclusions and recommendations may actually have quite negative consequences for the company's reputation, its ability to access finance and trade assistance, and for public procurement decisions. I will now briefly address a special field of arbitration, investment treaty arbitration, which could become an additional complementary option for the resolution of business human rights disputes. Now, there is increasing overlap and interaction between international investment law and human rights law. Some investors have attempted to enforce human rights claims in investment treaty arbitration. Currently very difficult. Such claims face significant jurisdictional hurdles. In addition, respondent states have occasionally brought counterclaims for human rights violations by investors. Again, there are jurisdictional hurdles, and most investment treaties impose obligations only on the contracting states, not on private investors. But investment treaty tribunals have nonetheless assumed jurisdiction over human rights counterclaims, and they have accepted that investors do have human rights obligations. Now, the leading case in this regard is Ibarza versus Argentina. The tribunal adjudicated a counterclaim for breach of the human right to water. The claimant company operated a concession for water and sewage services in Buenos Aires, and the respondent state claimed that by failing to make the necessary investments in the concession, the company violated the human right to water. Now, the tribunal relied on the UN guiding principles on business and human rights to hold that private actors do have an obligation to refrain from activities aimed at destroying human rights. Now, the tribunal stopped here and held that a positive obligation to protect human rights would only be incumbent on the contracting states. And since Argentina had invoked only a positive obligation, the tribunal dismissed the counterclaim. There are, however, at least 2 investment treaty tribunals that have upheld counterclaims. The tribunal in Burlington versus Ecuador upheld a counterclaim for environmental damage. That claim was based on breaches of domestic environmental legislation enacted pursuant to the Ecuadorian constitution, which protects the collective right to a healthy environment. The tribunal granted the counterclaim, and it awarded the state $40 million for soil and groundwater pollution caused by the oil and gas operations of the investors' local subsidiaries. The other tribunal that upheld a counterclaim for environmental damage was the tribunal in Perenco versus Ecuador, which awarded the state more than $50 million. Now, currently, only 0.5% of all investment treaties in force refer to human rights. But the integration of human rights law into international investment law has become a very important concern, and investment treaties may actually become a tool to promote responsible business conduct in accordance with human rights law. Now, some recent investment treaties impose human rights obligations on investors, and thereby eliminating an important hurdle for holding investors accountable for human rights violations in investment treaty arbitrations. Now, for the 2016 Nigeria-Morocco bilateral investment treaty, for example, requires investors to uphold human rights in the host state, to act in accordance with core labor standards as required by the ILO Declaration on Fundamental Principles and Rights of Work, and to refrain from managing and operating investments in a manner that circumvents human rights obligations. Our similar investor obligations are contained in the 2008 Supplementary Act on Investment of the Economic Community of West African States. Now, even under these investment treaties, however, victims of human rights violations have no right to resort to international arbitration. It is only investors and their home states that may do so. So in the context of the investment treaty reform process, proposals have been made to provide victims of human rights violations with direct access to investment treaty arbitration to enforce their rights. Now, this proposal would eliminate one of the main obstacles for business human rights arbitration, overcoming the reluctance of companies to agree to arbitrate human rights claims. So investment treaties could condition the enjoyment of treaty protection on the investor extending an offer, a standing offer to host state nationals to arbitrate human rights claims. Alternatively, the host state's consent to arbitration could be conditioned on the investor's consent to arbitrate alleged human rights violations. Now, realistically, given the costs associated with investment treaty arbitration and the level of expertise required to successfully pursue investment treaty claims, it will be critical that such claims can be brought on behalf of victims by the host state, by labor unions or other associations, and that proper funding will be in place for claimants. Well, thank you very much. That concludes my brief introductory comments, and I look forward to our discussion.
Thank you very much, Claudia. We can see that you have a lot to share with us in today's webinar. So permit me just once again, for those of us that are just joining us, welcome to the Nigerian Institutional Arbitrators webinar on access to remedy, the role of alternative dispute resolution, ADR, in business and human rights agenda, being organized in conjunction with United Nations Human Rights Special Procedures, United Nations Development Programs, International Law Association Nigerian branch. I would like to call on the second panelist for today, Tolulokpe Aderemi. But before I do that, I would like to say that one of the key points that Claudia talked about, which I think is something that we can actually borrow from in this part of the world, how to do with the investment treaties. And therefore means that with the new initiatives that we see from the AGRUs, as well as the Human Rights at Sea Arbitration Initiative, there's definitely a need for the investment treaties to become compulsory for investors to agree to sign onto the PRR, the UNGP framework, to ensure that not only are states liable to investors, but also that can be held accountable for human rights violations in the host communities where they do business. And so Tolulokpe is a partner at Pechstone and Grace LP, heading the Energy Practice Group at the firm's law office, a John Taylor Scholar from the University of Aberdeen, and a doctoral fellow at Durban University of Technology. Tolu holds a postgraduate degree in oil and gas, a BL from the Nigerian Law School, and an LLB from the University of Ibadan. He has extensive experience in domestic and international arbitration, with over a decade of experience in the energy sector. Tolu has handled complex transactions and commercial arbitrations in oil and gas, advised on local and international transactions, commercial litigation, government advisory service, and cross-border disputes. He holds several key positions, including the chairman of the Arbitration Committee of the International Law Association, a member of the Commission on Arbitration and International Chamber of Commerce, Paris. Tolulokpe is known for his transformative desire to impact society. He is dedicated to excellency, change, and serving humanity. Tolu, please, in 1 minute, could you respond to the keynote address of Professor Olawiyi, and we can take some other panelists. Please go ahead.
Thank you. Thank you very much, Director General. I'm only confused and struggle with how I will do that in 1 minute, particularly listening to Professor. I mean, you can't respond to Professor Olawiyi in 1 minute, certainly not. Those issues that he raised are issues that I think are quite important, and we must practicalize them. And let me start by saying, and thank you very much, Nika, for for inviting me to join this distinguished list of panelists. The question or the topic or the theme, ADR and human rights challenges, I think is one that is apt, is one that calls for even us as a country to revisit. And very quickly to respond to Professor Lawi on whether or not the new act speaks to it, not quite. And I'm sure during conversations, we will open that up. But I think it's important to note, this question of human rights is one that is complex. And when you talk about it in relation to the challenges in the business community, and for us to get any good traction out of it, we must be innovative, we must be proactive, and requires a collaborative approach. And you'll see what I mean when we open it up. In trying to think about this topic, I asked myself two questions. What about AD, which most of us know about or are learning about? We're talking about human rights and we're talking about businesses. Now, these are two components or two complex entities that are rarely used side by side. Could they be an oxymoron? Maybe perhaps. And so then you need to ask yourself, what does human rights mean? I'm not going to quickly jump into whether or not ADR is for commercial causes or non-commercial causes. But let's even look at whether, I'm very pleased with the work done with the 2019 Hague Rules on Business and Human Rights Arbitration. Well done. It's a good document which I commend to everybody to please take a look at, as it amends some key portions of the CITRA rule. But let's come back to what does human right mean vis-a-vis businesses and whether or not ADR is a panacea to solving that problem. And I went to the UN Professor Davilola's platform, and I discovered that human right means rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, and any other status. In other words, your right to life and liberty, your freedom of slavery and torture, freedom of opinion and expression, right to work and education, dignity, fairness, respect, and equality. And I'm asking myself for one moment, all of these are quite detailed, they're quite deep, and they are matters which can be resolved by the ADR. But what is the practicality of doing so? And I say this within the context of the reasonableness theory. Am I saying it's not possible? No, it's possible. But what's the reasonability of it? Interestingly, the Director General and I are privileged to be on the same committee that put together the Nigerian policy on arbitration, which is yet to come out. It was a federal government assignment. And in that exercise, we were even struggling with determining contracts that are Commonwealth contracts from non-Commonwealth contracts. Because at the moment, we're trying to develop a framework for the entire states at the federal level and or at the subnational level. And then you want to ask yourself, in using ADR, which we're quite proud of, is done extremely well across the world in terms of this resolve commercial disputes. But let me take one peculiar example, which I think most of us in Nigeria may be familiar with today, and then ask ourselves one question, whether we believe ADR is one that can solve that question. And what is that question? The current dispute, which dispute between the Nigerian Labour Congress, the TUC, and of course, the Nigerian federal government. And you know, I spent time trying to think about what is the best way by which this can be resolved between the federal government and the state government. Yes, right to a living wage is also part, of human rights under labor laws. But can we really use ADR in the context in which we're using it to resolve that dispute? On the one hand, the federal government is adamant as regards inhibiting resources and constraining cash flow. Whether that's true or not, that's a different conversation. The labor, on the other hand, are concerned that the excessiveness of government demonstrates that it has the ability to fund the new wage bill being demanded. That's also Labour's view. How does ADR, because what you find here, ladies and gentlemen, is disregard for the law. And I'm even talking about the law with coercive powers. The Honorable Attorney General came out, issued a statement to state that whatever it is Labour is doing is contravening decisions of the court. Regardless, I've not seen anywhere where Labour has responded to it, whether or not it's disregarding any court order. And so even at a level where you have coercive powers of the court being invoked, there's still flagrant violation of those orders. And I'm asking myself, can ADR play a pivotal role in business and human rights abuses within that context? And that takes me very quickly. And Madam Director General, I'm still within my 1 minute, even if I say so. It takes me to, I won't dwell so much on what are the advantages of ADR. We're all very familiar with those advantages. We sing it and, chew it every day. But in this context, could we have disadvantages? I've always said, anyway, I've had the opportunity to speak, that arbitration as opposed to ADR, and there are two different things. I always say arbitration and alternative dispute resolution mechanisms are separate, even though mediation now is now binding. But what are the challenges that it may pose? The first one is the question of jurisdiction. And I think Claudia was spot on in her opening remarks when she spoke about consent to the use of the process. That's a major drawback for this procedure. And so where parties have not, prior to the commencement of the dispute, indicated a preference for a mechanism for resolution, then it becomes a challenge. Of course, in practice, we also have the submission agreements. Most often not. I mean, take the NLC, for example. If today there was a prior agreement to resolve using arbitration, for instance, I'm sure they will go to arbitration, but will they respect those orders? Court orders, they struggle to respect them. But let's assume there was no prior agreement. Of course, you would rarely get their cooperation with it. And so question of jurisdiction becomes a major issue. Let's draw down a bit to matters related to awareness. And so, yes, the ADR, I'm very impressed with, the Hague Rules and the business and human rights arbitration. I think it's a document for us as a country. We must look into it a bit more closely and draw from it even to propose an amendment. We're already discussing amendment of the 2020 Arbitration Act. We must draw from it to propose new amendments, which is the nature of disputes that we're envisaging under this context are disputes, to my mind, I'll be speaking about challenges and solutions side by side, are disputes, to my mind, that may be resolved prior to getting to the stage of mediation or even arbitration. And what do I mean? There's concept of establishing dispute boards. And if you're familiar with construction disputes, construction arbitrations, you will know what I'm talking about. Now, dispute boards are boards that are set up and are part of a business or part of a structure which monitors, which complements a construction contract on perhaps case-by-case basis. And what it does is that it looks at the rights, it looks at the obligations, it looks at the potential disputes, such that before those disputes occur, they quickly identify them and they seek to manage them. That's the principle behind dispute avoidance and dispute resolution. And so for ADR and this topic to work, we really may be looking at dispute avoidance as opposed to dispute resolution. For me, to protect the human rights of parties in business, I think we're better off with dispute avoidance. This matter was also underscored by the fact that there's lack of awareness. Even the basic rights in the contract, parties are not aware of it. Number 3 is question of power imbalance. And Mrs. Should just give me 2 minutes. I'm going to round off now. Even if I've added 1 more minute to it, I'm rounding off now. You see, there's question of power imbalance. And so when we are discussing, using ADR to resolve, and take the NC example I've given you, you clearly, most times, within disputes of this context, you have the power imbalance. And where you have the power imbalance, it tilts more to one side than the other. Enforcement of those decisions becomes a challenge, particularly across the continent of Africa. I wouldn't say when we get to discussions, I'm sure we'll open up to that. There's this unwritten or unsung resistance to ADR culture and mindset. I think is deep-rooted, particularly across the continent, and this is one of the major concerns we arbitration practitioners we have. And because of our confidentiality nature, you see, there's also lack of or limited precedents. And so when we speak here today, we can speak about personal experiences as practicing arbitrators. Unfortunately, we may not be able to mention names. We may not be able to make references to how some matters have been well resolved in the past. So yes, ADR has its unique advantages in resolving disputes within the context of our conversation of this evening. But we must look at it very carefully, identify its challenges, some of which I have enumerated. Matters relating to dispute boards might be a solution to effective resolution, of disputes within the context. I thank you very much. I will stop here, and I'm sure we will engage ourselves more during the question and answer. Thank you.
Thank you, Tolu, for raising further issues and points on today's webinar agenda, particularly when you talked about the issue of power imbalance that we know. There are also remedies to it, and I believe that the new Arbitration and Mediation Act, by having a clause or sorry about that. It's been raining heavily here in Lagos, but I think it's coming down now. So I would just like to say that the issue of third-party funding also may be one of the areas in which we can address the power imbalance and the cost of arbitration in using arbitration as a remedy for effective remedy for resolving human rights and business-related disputes.
That's an issue you should please ask Mrs. Osho. It's a conversation you should have. It's one ongoing currently at the London Dispute Week. And I'll be happy to share some thoughts regarding some of the challenges, even with matters relating to third-party funding and what is coming up. Thank you.
We would look at that. Okay, I believe that it's a conversation that is going on, and for us in Nigeria, it's almost like a new era. But we already have some laws that will help us in being able to situate business and human rights related disputes using arbitration as a dispute resolution mechanism. Before I call on the next panelist, David Leader, I crave your indulgence to please request that all panelists, keynote speaker, and the president and chairman of the Nigerian Institute of Chartered Arbitrators, please put on your videos for us to just have a group photograph of panelists featuring in today's webinar. Please put on your video for us. Thank you. Thank you, everyone. Please, could you just take a snap of everyone? Okay, so while we're trying to take a photograph of everyone, let me just quickly introduce the next panelist, Daniel Leader. Daniel Leader is a barrister and partner at Lake Day International Law Department, specializes in international human rights and environmental law, with a particular focus on business and human rights. He has extensive experience of cases against different companies, complex group actions, and mass tort claims, as well as cross-border disputes and jurisdictional issues. Recent cases handled by includes Logway and Vadenta, 2019, UKSC 20, and Ukbabi and Royal Dutch Shell PLC 2020, UKSC, in which the United Kingdom Supreme Court significantly expanded the potential scope of parent company liability, is ranked by chambers and partners as a global market leader in the field of business and human rights law. Daniel Leader just joined us, I believe, after the keynote address. And so he will have the floor, but I just wanted to, in the light of what we've discussed, raise 1 or 2 points for him to share some light on, and the issue of the top cases that you think, or the top 3 issues that you think are crucial for you in business and human rights, as well as some of the submissions of Solu Lokme Adiremi on his position on the present situation that happened just recently in Nigeria. How do we use arbitration to resolve human rights or business-related issues? Nigerian law unions recently had a face-off with the federal government of Nigeria. It's still ongoing, even though they suspended it. How can we apply arbitration to resolve such disputes, given the power imbalance and some of the challenges I'm sure you're aware of that currently a lot of African states are facing when it comes to dealing with labor unions in this jurisdiction. So Daniel, you have the floor.
Thank you very much. It's an enormous honor to be invited to be with you this afternoon. Can you hear me properly?
Yes, we can.
Yeah, I'm seeing some nodding faces. I've done a lot of work in Nigeria. I have a lot of friends in Nigeria, so it's a particular pleasure for me to be invited amongst you to talk about these important issues. As Shola said, I'm a business and human rights specialist, and I've been working in this field for about 25 years. And in that time, I've seen enormous change. I started my interest in this field when I was living in DRC Congo. And what was clear is that multinational companies around the world were profiteering from an incredibly serious war where millions of people died, and where the natural resources of Congo were being bought and sold in Western markets without any questions asked. And that's really what got me into the whole business and human rights issue. And since that time, I think we have seen a real step change in this area of law and practice. 20 years ago, there was almost nothing you could do about a multinational company from the global north that was profiteering from human rights abuses. And now there is quite a lot that you can do, some of which has been talked about by my colleagues on this panel already. Now, Lead A is an international law firm. We work around the world, and we specialize in holding to account British parent companies for serious human rights and environmental abuses which have been committed by their subsidiaries. And what we have pioneered over the last 25 years is a whole new area of common law jurisprudence, which has culminated in Supreme Court decisions in the last few years, whereby the Supreme Court has accepted the principle that British parent companies can be held to account for the harms committed by their subsidiaries, depending on the facts of the case. But they do say potential liability can arise in many, many different circumstances. And the old model of corporate liability, which relied on the corporate veil and the separateness of legal personalities, that still applies clearly. But if on the facts it is the case that a parent company is involved in some way in the harm that has been committed, that can give rise to a separate duty of care in tort. We have seen now the cases of Vedanta, which concerned a large Zambian copper mine, which went to the Supreme Court, but also more recently the case of Okpabi and Shell, which concerned oil spills of 2 communities in the Niger Delta, where the Supreme Court unanimously held that Shell PLC could be held responsible in British courts for these harms which had been committed. Now, I should say that these cases are ones where it is clearly better to litigate them in the countries where the harms have arisen, provided the victims have clear access to justice and there is no real risk of injustice. As many of you will be aware, there are real difficulties in many parts of the globe for poor communities to prosecute their rights, their human rights and their civil rights in courts of law. It's very difficult in many situations for them to access lawyers, to pay for expert evidence, to pay for those lawyers, to take on the might of multinational corporations. And it's my real wish and hope that over time that will change, and more of these cases, these big mass tort group action cases, will be litigated in countries where the harms have occurred. But it's also equally important that where parent companies from the global north have profiteered from serious human rights and environmental abuses, that those British or French or American companies are themselves held to account by British, French, American courts, so on and so forth. And we're seeing a real trend around the world, and I would say it's picking up enormous steam now, of courts being open to these kinds of cases. In the last few years, we've seen the decisions from senior courts, appellate courts in Canada, in France, in the Netherlands, in New Zealand, and elsewhere, where the decisions have been made which are akin to the jurisprudence of the Supreme Court in the United Kingdom. In tandem then with that, there is now the Human Rights Due Diligence Directive of the European Union, where all 27 states have agreed to sign up to a law which holds companies domiciled in their jurisdiction to account for serious human rights and environmental abuses, and places quite strenuous legal obligations on them. So the world is changing, and I think it's changing fast. And I think there will be a real step change in the amount of cases that are happening around the world, whereby communities who have been really badly affected will be able to assert and prosecute their rights. One of those places is the Niger Delta. And there are real issues, as many of you will be aware, of polluted communities who have been living with absolutely chronic levels of pollution and have not had any cleanup for decades in some situation. So in some cases, there are real issues about how they can prosecute their rights and access justice against some of the most powerful companies in the world. And that one of those cases, the Ogali and the Bille cases, is currently going through the courts in the UK, but there are others going on in the courts of Nigeria, of which you will be aware. I was asked about ADR and arbitration. I can say this about ADR. There have been now increasing examples of very creative ADR solutions which have been brokered as a result of ADR with companies to provide remedy to impacted communities. Over the last few years, myself and other colleagues have been able to come up with settlements or agree settlements with corporations in numerous countries around the world, which have provided remedy to the victims in terms of damages for harms done. But in addition, they have also provided community projects, trainings, scholarships, buildings of schools, the building of roads in some circumstances, the implementation of operational grievance mechanisms. All those have been part of a holistic package of remedy for victims from various communities who've suffered serious harm, sometimes for numerous years, in order to improve the situation between the corporation and the communities in question. Many of those examples are on our website, which we would invite you to go to. But with regard to arbitration, the difficulty and the standing of communities to engage with arbitration, certainly at the investor state level, has already been mentioned by my colleague Claudia, or by my co-panelist Claudia. But there are equally the Hague rules on business and human rights arbitration, which have now come into force. I'm not aware of any examples as yet where those rules have been tested and had been used to any great effect. But in principle, there is no reason why, if there is an ongoing and serious dispute between a community and a multinational company, both parties cannot elect to use arbitration as opposed to courts as a way of resolving those disputes. And again, there is no reason in principle why very creative ADR solutions cannot be found in the context of arbitration proceedings. Finally, I was asked to mention some of the key cases on business and human rights which have been have happened over the last few years. In the UK, I would mention the Vedanta case, Lungowe and Vedanta, and also the Okapabi and Shell case, which sets out the principles for parent company liability in the UK. But obviously that has wider implications and applications across the common law world and is being used as precedents in numerous other jurisdictions, from South Africa to New Zealand, Australia, and Canada. In moving to Canada, I would mention the case of Nevsun, which concerned a mine in Eritrea, where there was a finding by the Canadian Supreme Court that multinational companies can be subjects of international customary law and can be found to be in violation of international customary law. And that was an extremely novel and important decision, which is having ramifications as well. In the case of Lafarge, the French Supreme Court, the Cour de Cassation, found that a French company, could be in breach of international criminal law. That concerned a factory in Syria and ongoing relations between the company and ISIS. And that in turn has led to prosecutions in the United States against Lafarge. And there was also litigation, very important litigation in the Netherlands against Shell, some of which was to do with oil spills in the Niger Delta, and another case which concerned Shell's climate change targets, which Shell was found to be in breach of, and that they needed to redouble their efforts in terms of climate change. And so I would cite those as some of the most significant developments that have happened in recent years, but the pace of change is fast. The jurisprudence that are coming out from the various courts around the world is increasing. And I think it's a very exciting moment. And I'm sure in due course, many of you will want to become involved, and some of you already are involved in business and human rights litigation. And I look forward in due course to working and meeting with some of you. Thank you very much.
Thank you so much, Daniel. Daniel, thank you so much. One major point that you made that got me very excited was when you talked about the fact that there is increasing creative ADR solutions to providing remedy to impacted communities. I think this is one area that those of us that are coming from this part of the world are interested in, find out more about it, how we can begin to apply that and hold multinationals as well as corporations responsible for pollution as well as environmental degradation that suffered by communities, not only in Niger Delta, but also other parts of Nigeria where you also have mining businesses going on. So thank you so much for that. I'd like to now call on the next panelist, Florence Shako. Florence Shako is a legal academic, advocate, and researcher specializing in access to justice and business and human rights issues. She holds a Master of Laws from the London School of Economics, a Bachelor of Law from the University of Nairobi, where she graduated top of her class. An advocate of the High Court of Kenya, she's a senior partner at Mitula, Shako and Associates, a law firm in Nairobi with a focus on social justice. Florence is an experienced arbitrator and mediator. She currently serves as the Vice Chairperson of Women in Alternative Dispute Resolution as the Kuala Arbitration Blog representative for the London Court of International Arbitration. Florence, you have the floor, and please, let's stick to 5 minutes. Thank you.
All right, thank you very much for the opportunity. Just to quickly thank Professor Fabian Ajobu and the Institute, Nigerian Institute of Chartered Arbitrators, for this opportunity, and to Professor Damilola for laying a strong foundation for this conversation. So I'll skip some bits since they've already been repeated, and I'll try and focus on Principle 31 of the United Nations Guiding Principles on Business and Human Rights. So what happens is that whenever you have non-judicial mechanisms such as ADR, whether it's arbitration or mediation or conciliation, as long as it's a non-state-based non-judicial mechanism, it's there to complement the existing judicial mechanisms, but it has to adhere to a certain effective criteria. So some of the criteria that you have to meet as an ADR mechanism is, for example, that it has to be legitimate. If you're going to use it in the BHR context, which is business and human rights, you have to make sure that there's trust from stakeholder groups for whose use they are intended, that it's a legitimate process, even if it's international arbitration. Is it being accountable for the fair conduct of grievance processes? It should also be accessible, which is something that I'm going to highlight towards the end of my presentation. It should be known to all the stakeholders, and they should be able to gain assistance from it. It should also be predictable in terms of the rules that can be used. So is everyone clear about the known procedure that's going to be used, the correct timeframes, and the clarity of every stage that is going to be followed? So that has to be there if it's an ADR mechanism. It must be equitable, it must be transparent for the stakeholders as well, and it should be compatible with human rights. Now, I won't go into the advantages of arbitration. I've been told to stick to 5 minutes, but the reality is, even though arbitration has made traction in investment, arbitration, commercial disputes, there's still some traces, and you can see some traction being done where international arbitration is already being included in agreements that are related to business and human rights. So I'll give you a quick example. For example, you find that there's international arbitration being referenced in relation to human rights and construction activity that's being undertaken in the lead up to the 2024 Olympic Games. So given what happened with FIFA and the concern over migrant workers' rights in Qatar, now you have the host city contract. The Olympic Committee is actually saying, look, as the host city, the one that is holding the Olympics, you need to make sure you're obligated to submit any dispute concerning performance of these contracts related to make sure that human rights are protected, including the migrant workers. So those who are constructing the stadiums, those who are involved in the Olympic Games, you should consider their rights. So you see some traces of international arbitration being used as a clause in some of these things. Bringing it home to Kenya, where we have the Kenya National Action Plan, part of our policy actions in our NAP is that you actually find this reference to the use of arbitration and this encouragement that whenever you have disputes, use ADR in line with our constitution, which recognizes the use of alternative dispute resolution in Article 159. But the problem that exists, and this is the crux of what I wanted to present today, is that the reality is there are obstacles when it comes to the use of international arbitration. One of the main obstacles in the context of business and human rights is accessibility. As rights holders try to pursue justice because they've been affected by this corporate human rights abuse, they face a lot of hurdles. One has been highlighted by Claudia earlier, the cost of international arbitrators. Can rights holders afford it? Is it something that for them they're able to easily afford? You find that that becomes an obstacle for them because there's substantial upfront administrative tribunal fees, legal fees, as well as even fees for the venue hire. So is it practical for the BHR perspective? There are also issues of consent, which I also won't drill down because Claudia highlighted that as well, but I'll add to that. For example, there are issues to do with the enforceability of arbitral agreements and awards, and that can make it difficult to secure in the case of BHR disputes. So for example, if you're going to go and enforce an arbitral award, an enforcing court can conclude that this tribunal did not have the jurisdiction to hear claims that have been brought by victims pursuant to this offer model of consent. They might not agree to it, and they might say these were not part of the arbitration agreement. Courts can also resist enforcement of an award on the grounds that human rights issues are just not arbitrable based on the public policy exceptions that are provided in the New York Convention. You also find that there's this debate whether the traditionally private nature of arbitration, will it have legitimacy as a mechanism for resolving business and human rights disputes? These are disputes that are in the public domain. We are talking about issues to do with forced labor in the supply chains like the agricultural supply chains. We are talking about environmental harms in areas that are surrounding a corporate project. Is it in our interest for it to be submitted to a private process? So the legitimacy is called into question. Also, there are these persistent issues. For example, you find there's underrepresentation of the global south and lack of diversity in arbitration. In panels such as exert, you find that there's major underrepresentation. Are we going to perpetuate this further and continue also in the BHR context? Then there are structural obstacles that are really a big hindrance when somebody wants to use arbitration in BHR. So for example, in the case of a right holder, it's often they are legally, financially disadvantaged compared with the corporate entity. You can't compare the victims and the right holders to the money that the corporate entities have. So besides the fact that even those corporations are more resilient, so they can bear the cost and they can keep these matters going. What does that mean for the victims when it comes to handling the complexity of even the structures of these corporations? They have an inability to obtain even information. You find multinational corporations refusing to publish the information. How are you supposed to engage in this process? So arbitration, sometimes, even though we want to have it in the BHR context, you find that there are these issues that are very insurmountable and that they create a barrier for those who may want to seek it, but it's not going to be available. The last thing I'll say is that when it comes to the right to access, yes, we recognize that rights holders should have the genuine possibility to institute proceedings before a remediation mechanism. But the reality is that for them, is it even accessible? Is it something that is realistic for them to get? If you're saying that I'm going to secure the consent of parties in a BHR context, for example, potentially you have multiple stakeholders and you have a coordination of multiple claims. Does this make sense for the victims? Are they able to get consent of all these victims for them to submit to the arbitral process? So it's not a matter of a lack of understanding or a lack of goodwill to submit to these processes. It's the fact that there's a latent blind spot, now taking us back to Principle 31, where even though international arbitration has all these advantages, we are not, and yes, it is legitimate, it is recognized. Is it really adhering to principles of accessibility? Can we really say that all stakeholder groups for whose use they are intended are being provided adequate assistance, even though they have these barriers that I'm talking about that are legal or financial? Those are key areas of concern. Can we really say they're transparent? When you want to have, even going outside of arbitration, when you want to have a mediation between a multinational corporation and a community, and you agree to certain terms, will the multinational now disclose their books so that you know, publish it there so that you can understand what exactly that community is entitled to? In Kenya, not so much, and I've been involved in some of those processes where we have not seen transparency. And that rights compatibility, we are saying, wow, a non-judicial grievance mechanism should be rights compatible. Is it? Will the courts agree that this is something that was arbitrable in the first place? So the move is definitely for BHR to try, and the reality is because of the multiplicity and the broad scope of possible human rights impacts by businesses, it's true that BHR forums, they can't be cabined into a single forum. They can be had in different forums. You can have it in domestic courts, you can have it even in the court of public opinion. But the question still remains, even for ADR, are we able to do it in a way that the global south can benefit? Are we able to do it in a manner, sorry, is this a, okay, I'm just winding up. Are we able to do it in a manner that is able to benefit the real stakeholders? Are we really bringing to life Principle 31 of the United Nations Guiding Principles of Human Rights? Or is it just rhetoric? Thank you.
Thank you, Florence. That's a good one. It's a good one. It's you're actually setting the tone for this section for our forthcoming annual conference in November. This is one section that we're going to place major attention to for the conference, because a lot of issues are coming up as to how accessible really is arbitration and ADR to resolving business and human rights related disputes. So permit me to invite the next speaker to take the floor. Idaweon Napoleon Idaweon Enayamba. Napoleon is a program specialist in rule of law and human rights at UNDP Nigeria. Napoleon has over 6 years as policy lead on security and justice at the British High Commission. He has developed key initiatives and acted as a vital liaison between Nigeria and London. In previous roles, his expertise spans governance, defense transformation, conflict resolution, public safety, and climate change. Notably, Napoleon led a partnership between the Nigerian government, UNDP, and the German government for police reform and contributed to the Nigerian Police Act 2020. He stopped the bribes project involved into the police complaint response unit. Napoleon is renowned for his relationship management skills and has successfully managed complex relationships at all levels. So Napoleon, please, if you could respond to one of the issues that Florence raised was the issue of lack of understanding and goodwill to submit to arbitration and the ADR process by multinationals. I would like for you to just respond to that for 1 minute, and then you can just talk to us about your views on the topic that is on the floor and what you have done in ensuring that UNDP also can play, a major role to support states and other stakeholders when the issues of BHR disputes come to the fore. Thank you.
Thanks very much, Shola, for having me. And I'll say thank you so much to NICAP for, extending this invite to me and standing in on behalf of the United Nations Development Program, UNDP Nigeria. I would say it's apt that this program is happening at this very time. Why did I say so? April last year, Nigeria endorsed its National Action Plan on Business and Human Rights. And obviously, that is Nigeria's way of working towards the implementation of the UN Guiding Principles on Business and Human Rights. And today, we're talking about a topic that is, of course, critical to the actualization of the third pillar, and as Professor Damilola had said. I wouldn't dwell so much on, but not to say it's not important, but to say that Nigeria's ability to also enforce its own laws is critical to ensuring that international concerns that dwells in Nigeria also complies with basic laws. And I think the Arbitration and Mediation Act 2023 obviously sets put in place strong basis for which Nigeria can leverage on its own laws to be able to enforce compliance of international concerns that are working in Nigeria to ensure that they comply with all requisite laws. I mean, what I want to do today is to look at how we cover a bit on what UNDP does globally and a bit of what we have been doing in country as well. I mean, with regards to the third pillar, what we try to do is to look at ways in which we promote access to remedy and to ensure right-based solutions and prevent future human rights abuses. But this is also with trying to or developing guidelines and toolkits to support businesses in managing human rights risk, including heightened risk and impact in conflict-affected areas. We also engage with companies to ensure respect for human rights throughout supply chain, including offering human rights due diligence training and closed-door guidance session. And of course, with the government, with our host governments, we try as much as possible to work with the host governments to implement the guiding principles through the National Action Plan. And of course, Nigeria being the third country in Africa to have endorsed the National Action Plan on Business and Human Rights, we're effectively working with the government of Nigeria to support the implementation of the National Action Plan through the National Working Group on Business and the National Working Group that has been set up. I mean, if you want to look at the importance of the ADRO with respect to businesses, you would first leverage or look at the peculiarity of our own country, Nigeria. the former court system is obviously critical in the scheme of things. But if you look at the time frame cases take in courts to materialize, and how that also dampens public confidence in using the courts, it raises the importance of what other alternatives are available to people. And I think this is where the alternative disputes resolution mechanisms become a veritable tool. And of course, taking into cognizance all that have been highlighted by previous speakers with respect to how alternative dispute resolution mechanisms should obviously be, and the features that it needs to have in place. So that said, what we are doing in the field at the moment is basically working through state structures to look at ways in which we support and reinforce alternative disputes resolution mechanisms, particularly in the Northwest. We are working there with the Chief Justice to look at ways in which we train, legal minds to be able to look at issues that don't necessarily need to be in formal courts, not necessarily because by mandate it shouldn't be there, but because the alternative dispute resolution mechanisms would help expedite and ensure justice for people whose rights may have been violated, whether as a result of engaging with businesses or even at individual level. And what we are finding on the ground is that we're seeing record that is far shocking. And I think that's why, that highlights the criticality of this discussion today. The fact that within a month, an ADR center was able to cover a case, number of cases that, resolve number of cases that were not resolved in formal courts over a period of 1 year. So this highlights the fact that sometimes our people, for some reasons, for reason of enlightenment, frustration with formal courts and level of education, would always prefer this sort of alternative dispute resolution options as a way of, seeking redress for cases where their rights have been violated. And I think these are well highlighted even in the UNGP's guiding principles when it talks about non-state-based judicial mechanisms and other mechanisms that can be explored in terms of seeking redress. The African Union is currently drafting its own policy at the moment, focusing on business and human rights. And one of the things that it seeks to bring into that policy when fully functional is to look at how they even explore traditional systems like the Gachacha system to look at ways in which they use that to also strengthen justice or access to justice for people who are seeking redress. So for UNDP, even though at this very point, multinationals are actually leaving Nigeria, but we also see government push to look at ways in which it encourages multinationals to come into Nigeria and, of course, invest. There is always this tendency that because we desperately need businesses to come into Nigeria, then we pay blind eyes to, the violations that may be perpetrated by these businesses. What we are trying to do from our own end is that even as we reinforce this sort of advocacy for businesses to invest in Nigeria, but there is also the need to ensure that we are proactively supporting a process where businesses are forces for good rather than forces of evil. And I think, there's always that, belief that businesses will bring development. No doubt, I think that is globally recognized that businesses will bring development, but there's also the need to ensure that rights of people are protected and that such things do not deteriorate into where people are left with no other options but to resort to self-help. And having these sort of structures that exist in terms of people having where they can seek redress where rights have been violated is critical. And in order to create, for people to even be able to aware that these structures exist where they have been created, there is need to create awareness. And these awareness need to be holistic in terms of how it is done. For instance, in the Northwest, where we are currently working on these alternative dispute resolution issues, we're using radio, program and jingles to create awareness in terms of what these structures and where they exist, and for people to maximize the opportunity that these structures bring. And particularly, people find it attractive, not because it resonates closely with them, but for a country where a lot of people cannot afford the cost of going to formal courts, these ADRO centers present great alternatives. So as UNDP, working on continuing working in this space and looking at ways in which we strengthen advocacy around structures that exist alternatively for which people can seek redress. Thank you very much.
Thank you, Napoleon. Thank you so much for that. Thank you for sharing with us the work that UNDP is doing in the business and human rights related space. I'd like to call on, last but not the least, panelists, Dr. Oyeni Abe. Dr. Oyeni Abe is a business and human rights specialist and research fellow at the Center for Comparative Law in Africa, University of Cape Town, South Africa. He has extensive experience in human rights, corporate and commercial law across Africa, Europe, and North America. Dr. Oyeni has published extensively on business and human rights, sustainable development, and natural resource management, and his latest book is on implementing business and human rights law in Africa. Dr. Abe has also consulted for the World Bank and the African Union. He serves as the Executive Council of the International Law Association Nigerian branch, and is a member of several esteemed organizations. Dr. Oyeni, I would like for you to address an issue that has to do with the responsibility and role of the state as well as corporate actors under the United Nations guiding principles to promote and maximize the use of ADR for business-related disputes. And tell us how these mechanisms can be better integrated in the business and human rights landscape. Please, you have 5 minutes to respond to any of the questions that the panelists have raised, as well as address this question that I've also added to it. Thank you, Dr. Oyeni, you have the floor.
Thank you, Madam Moderator. Can you hear me very well?
Yes, I can. Please
Yeah, thank you. Yeah, thank you, and thanks to the organizers, the NICAP, for the kind invitation. So very briefly, what I've been hearing so far is a kind of an analysis or reassessment of arbitration paradigms in Nigeria, and so to speak globally as well. And I hear about, whether the question of whether the act takes care of arbitrating human rights issues, the problem of enforcement, the problem of jurisdiction, and which makes me to question or wonder that if indeed arbitration was actually introduced as an alternative to litigation, especially in a country which is highly litigious, or which traditionally we have always known litigation as the only means of resolving disputes. With all these rules, with all these procedures, has arbitration actually come to mitigate or even complicate the litigation practices? And these are questions. These are more like rhetorical questions or or questions to ponder. And going back to the keynote speaker or the keynote speech, we'll realize that the UNGPs calls for a smart mix of regulatory and voluntary approaches. And the keynote speaker highlighted the different features of the third pillar in terms of coherence, clarity, legitimacy, and effectiveness, and how we can plug gaps in information and awareness. But what I would like to speak on is just take a step back and look at what can actually happen at the pre-arbitration stage as a form of remedial mechanism. How do we prevent human rights violations instead of waiting for and until when it does happen? You look at most multinational companies today in Nigeria, most of them are very strong legal departments with trained lawyers designed in the art of litigation. When issues like pre-arbitration or pre-grievance stage occurs, how do we ensure that we kind of, quote unquote, kill or settle the grievance before it escalates into the arena of conflict? And as Daniel pointed out as well, refer to some of the cases which have settled out of court, the Opabi case, the Billion cases. The question is, why wait till these cases were filed in court in the first place before you asked, okay, can we now settle out of court? So my intervention would be on the intersection of business and human rights and arbitration and ADR mechanisms. And I would like to draw attention to the UNGPs, which is an operative normative document that guides the business and human rights discussions. And how do we make operational level grievance mechanisms work? So operational level grievance mechanisms is a fundamental aspect or feature of non-state-based judicial mechanisms, which the UNGPs highlights. And if I could quickly refer you to GP Principles 28 and 29, GP 28 talks about OLGMs, the operational level grievance mechanisms administered by business enterprises alone or with stakeholders. They are non-judicial and they may use adjudicative, dialogue-based, or other culturally appropriate and rights-compatible processes. And GPs 29 says to make it possible for grievances to be addressed early and remediated directly, business enterprises should establish or participate in effective operational level grievance mechanisms for individuals and communities. So the UNGPs already has created an avenue for us to integrate arbitration and indeed other ADR mechanisms within the business and human rights landscape. So it admits of two-pronged approach, what I can call a two-pronged process. These OLGMs support the identification of adverse human rights impacts as part of an enterprise's ongoing human rights due diligence. And you see countries all over the world coming up with due diligence directives, as Daniel referred to, the EU Corporate Sustainability Due Diligence Directive. We have France with DTO vigilance law, and other countries around the world coming with due diligence laws. And the second approach is that this OLGM mechanism makes it possible for grievances, once identified, to be addressed and for adverse impacts to be remediated early and directly by business enterprises. So it's kind of identify it and address it at a very early stage without having the need to go to the realm of grievance, either litigation or ADR mechanisms. And the reason for this, it prevents harms from compounding and grievances from escalating. So the starting point is how do companies develop OLGMs? And as a keynote speaker identified, we assume that some of these grievances are related to multinational companies, right? SMEs, and I'll speak briefly on what the Committee on Business and Human Rights and ILA Nigeria is doing in this area. SMEs are also part of the discourse, and the UNGP talks about all businesses, irrespective of shape, size, formation. They must key into appreciating the human rights impact of the activities, especially vis-a-vis the local community. So the starting point is developing OLGMs in line with an effective criteria which has been set out in the UNGPs. You cannot just plant a grievance mechanism into a context if there is no dialogue framework in place. right? And the considerable questions will go into the design of an effective OLGM, but this alone will not solve the problem of how to make OLGMs work in practice. So there's a need to look at the broader context and the ecosystem in which they are going to operate in terms of internal mechanisms of companies to ensure that this opportunity arises for complaints. How do we ensure mechanisms for independent support for affected individuals and communities? How do we ensure oversight? How do we empower marginalized or vulnerable people? And the reason why this is important is when you look at instances where conflicts do arise, and Niger Delta has been identified, you discover that the interaction with local communities are usually with the companies, not with state entities. So that is why, even though the states have duties to protect international law, to protect human rights, and then to ensure the enforcement of international laws, you realize that local communities interact with businesses more. Rather than, if there are no good roads, there are no good hospitals, who do they turn to? The businesses, because these are the people they interact with on a day-to-day basis. So that is why there's a heightened approach. And as the keynote speaker said, the realm of the Westphalian approach, Westphalian idea that states, positive obligation of states only have duty on international law. We've gone beyond that. Companies who are much more richer, financially much more buoyant than states, now have that responsibility. So let's look at extractive industries in Nigeria, for example, ensuring that well-functioning and legitimate OLGMs may prevent minor issues from escalating. And I don't want to go into the examples that have been identified, Opabi and Shell, Apan and Shell. These would have been solved through an effective ADR process, which, if a company has an operational level grievance mechanism, this would have been identified and addressed at a very early stage. So companies, therefore, have to achieve a balance between ensuring that company policies are implemented consistently on the ground and that OLGMs are appropriate to local circumstances, right? And the steps are taken internally to ensure that all key internal stakeholders are on board to ensure that OLGM outcomes are implemented in practice. So a critical case in point where this OLGM has worked very well in the recent past is the case of the Kenyan floriculture, which is a good practice story of a multi-stakeholder governance towards the protection of women workers' rights and their access to grievance and remedy. The Kenya floriculture sector, employs a significant amount of workers, and then it underwent a gendered process of economic and social upgrading during the early 2000s. So what that initiative did was take a decisive product upgrading. It underwent a crucial switch from temporary to permanent contracts, which is critical for local communities. We talk about local content, which meant that workers were now members of the union, integrated into the day-to-day administration of the company, and then giving them access to another main channel to grievance and remedy. So this synergy between companies and the local communities or host communities is what is critical if we are really going to address the issue of grievance mechanism. The state is there. National law, it's pretty much difficult for us to sue multinational companies. We can't, of course, states can be sued. So I don't really want to dwell much upon the state's responsibility as much as corporations having a heightened responsibility to integrate some of these principles and mechanisms in their modes of operation rather than wait until when relationship actually breaks down. For the Business and Human Rights Committee in Nigeria, we're in partnership with the National Human Rights Commission in Nigeria on awareness, information dissemination. As has been mentioned, we currently have a national action plan for the promotion and protection of human rights, which included a chapter on, I think it was adopted in January 2024, which declared a chapter on business and human rights. And we have, it's not just having that law, we also have to create an awareness, information, sensitization about how that law works in practice.
Thank you. Dr. Please, you have 1 minute left. Just wrap up, please. Thank you.
Okay. Okay, I will just wrap up now. And so we are also engaging with businesses, especially the SMEs at the local level, on how to integrate human rights principles in their modus operandi. And we're conducting several workshops and webinars on business and human rights. We actually had one yesterday to celebrate World Environment Day. So we need to facilitate dialogue. We need to provide expertise and enhance compliance. And I think ADR can really indeed contribute to addressing human rights abuses and promote corporate accountability. Thank you.
Thank you, Dr. Yeni. Thank you for your presentation. I believe, thank you so much to all our panelists, keynote speakers, as well as President and Chairman of the Nigerian Institute of Arbitrators for your kind remarks. I would like to take a few questions from our attendees. The first question says, please explain the intersection between business and human rights in the context of arbitration. I don't know if Claudia, you could speak to that in like 30 seconds. The intersection between human rights, between business and human rights, as well as, sorry, please explain the intersection between business and human rights in the context of arbitration. Hello, Claudia, are you with us? Okay.
Can you hear me now? Sorry. Yeah,
Yes,
I had trouble hearing correctly the question. The question is interaction between businesses and human rights.
Human rights. Yes. Intersection between business and human rights in the context of arbitration.
Okay, well, that's a huge question that could fill a whole seminar, I think. I think there are two very different scenarios. One scenario where you have arbitration between private parties, or arbitrations, mixed arbitrations between the state and private parties, and where human rights obligations and compliance with human rights obligations comes up in order to solve that dispute. That happens quite often, actually, in investment treaty arbitration, but it also comes up in commercial arbitration, and it is quite relevant also, not only to the merits of the claims, but to the amount of damages that may be sought. Yeah. So that's one area. The other area is what we've been discussing today for a while now, where victims of human rights violations seek to hold businesses directly responsible, and they may do so through arbitration. Now, that's what the Hague Rules, the 2019 Hague Rules on business and human rights arbitration are about. They are designed to facilitate direct access by victims, claims based on human rights violations by companies. So I think those are the two main areas. Of course, there is tons to say in each of these areas, but I'm conscious of the time constraints that we have.
Thank you. That's an apt response. Thank you very much. The next question goes to Daniel, and the question is there a specific international standard or guideline on how to calculate various losses resulting from business-related human rights violations?
I think Daniel stepped out already.
Oh, okay. Okay, we'll move on to the next question for Florence. We'll see if we can take that if it comes back in. Florence, how do we deal with violations caused by security? For example, the Tanzanian police forces were involved in the violations while guiding the mine. I don't know if you have some insight into this matter.
You said, how do we deal with violations caused by?
Yes, how do we deal with violations caused by state security? And he gave an example, the Tanzanian police forces who were involved in the violations while guiding the mine?
Right. So it's interesting when it comes to state responsibility, because I know we've talked a lot about Pillar 3 on access to remedy, but even states themselves have a duty under Pillar 1 of the United Nations Guiding Principles on Human Rights to uphold human rights. And that extends not just for them to respect human rights as states, but to make sure even the companies that operate in the territories in which, so let's say transnational enterprises, as long as they're operating there, they should be held responsible for any violation of human rights. So the state responsibility is under Pillar 1, and it's still there. They have a duty to respect human rights, to even prevent human rights, and where they occur within their territories, to make sure that the people who are responsible are held accountable. And that's where now also the remedies come in, because the accountability now comes through either judicial mechanisms or now like what we discussed today, which is non-judicial mechanisms. But from the example that's been given, it sounds like even judicial mechanisms would be apt in that context. But the states do have a duty to respect human rights as well. The interesting thing is that for a long time, business and human rights, what had been perceived was that states had the responsibility and individuals had a responsibility to respect human rights. But what we are saying is that with the business and human rights context, now it's not just the state and it's not just the individual, but even businesses should have what we call corporate respect for human rights.
Thank you very much, Florence. This question goes to Professor Olawe. The question says, what role can human resource practitioners play in promoting a culture of alternative dispute resolution within their organizations?
It's a very good question, and I think not just human resource professionals. I think even lawyers, if you are drafting any contracts, even if it's an employment contract, include an ADR clause. If you are in the HR business and you are developing your grievance mechanism, grievance mechanism simply means if I'm offended at work, what should I do? Then include ADR. That, well, we will resolve it through mediation. We will resolve it through arbitration, because this issue of access to remedies is not just for states. Every business should actually have a grievance mechanism. That is the message you are passing across. So include ADR in your grievance mechanism.
Okay, I think you should just continue with the next question. And the question says, how can ADR be used to address, okay, I think it's similar, or maybe you want to share some words on it. How can ADR be used to address workplace discrimination, harassment, and other human rights violations?
Yes, you're very correct that it's very similar, and it all starts with the policy. When we were on a country visit in a country the other time, and there was this case of sexual harassment, and we asked, the lady complained, and we asked the company, what did you do? They said, well, she reported, and that they asked the same boss that she was complaining about to investigate the matter. And I said that is a violation of international law. So there should be a mechanism in place. There should be a policy in place that will provide, accessible and transparent opportunities to resolve any dispute, whether it is sexual harassment and all of that, in accordance with human rights norms. So it's all about legitimacy, and it should start with the policy. Is there a policy in place? If there is no policy in place, the company should design one. And then such policies should also reference mediation, conciliation, arbitration, such that no one will need to go to court because of some of the challenges that we've discussed with litigation.
Thank you, Professor. So now, hello.
I think Tolu wants to add to that.
Yes, I actually was going to come to Tolu. There's a question for him here. So just trying to address some of the questions raised by attendees. Tolu, this question is for you. The question has to do with does the present Arbitration and Mediation Act take care of arbitrating human rights issues in Nigeria?
Okay, thank you very much. And I think we had that conversation.
30 seconds. 30 seconds, Tolu. I know you have a lot to.
I seem to be the only person you give time limits to on this panel, and I crave the president's permission to give me cover. Now, I think in relation to the first point, which Prof also said, question on the HR, I think it's important that HR structures, and not just HR, business remedial structures start considering dispute avoidance over dispute resolution. That's a concept which we developed in Egypt a few years back, and I think is becoming a recurring point at the ICC conference in Paris, or somewhere, no, in Miami 2 years ago. It also came up. Dispute avoidance needs a dispute board. The HR professionals must understand that within a business structure, you must have a dispute board. The purpose of that dispute board, one, cures the point of conflict, which Professor Lawi just mentioned a few minutes ago. The second importance of it is when you have dispute board, they help you with dispute avoidance as opposed to dispute resolution. We can speak much more about that much later. To the main question whether the Constitution, the Arbitration Act recognizes human rights. Was that the question?
Yes, that's the question. Is that does the new arbitration and provide?
Thank you very much. You see, the challenge with that, and I'll put them just in three compartments. The first one is when you look at human rights violations, you can have them in two compartments. There's actual violation of human rights. There's potential violation of human rights. The actual violation of human rights is what is more realizable or realistic. But what you find most times is a potential violation of human rights. Now, in the Arbitration and Mediation Act and arbitration principles, generally and across the world, arbitration does not recognize potential violations of the contractual rights. And of course, that takes me to the question as to whether or not human rights are contractual or commercial in nature. I think we dealt with that earlier. So the simple answer to your question is the Arbitration Act does not recognize it in that sense. And what you find is just not restricted to Nigeria, unfortunately. Most of the African countries who have the arbitration provisions or arbitration laws fashioned or drawn after the UNCITRAL model law have similar provisions. So for example, when you go look at the footnote on that Article 1 of the UNCITRAL law, it gives you an idea of what are the sort of cases that can come within its province. Thank you. You will have to unmute yourself, Mrs. Oshodi John.
Thank you, Professor Lawi. Last question for the webinar. I'm afraid we can't continue anymore with the questions. But like I said earlier, we are going to have this same team as part of our conference team at our forthcoming conference in November. So if you want to hear more and you want further discussion on this, please join us at the NICAP annual conference on ADR and arbitration, 27th of November to 27th to the 29th of November. But before I wrap up the question, there's a last question that I think is very vital that Claudia, please respond to for us, if possible, in 30 seconds. It says, is there a specific international standard or guideline on how to remedy, calculate various losses resulting from business-related human rights violations? Is there a specific international standard or guideline that has been put in place?
No, unfortunately, there are no specific standards, and the general rules applicable to state responsibility apply, and in the modified version, arbitral tribunals would also apply them if they are adjudicating human rights claims against businesses. So that's a very good question. It's probably something that we should think about. I think arbitral tribunals benefit a lot from more specific guidance. Of course, human rights courts are confronted with this question on a daily basis. So one could also think of drawing some guidance from the practice of human rights courts. But human rights courts, unlike arbitral tribunals, would generally not award monetary damages, but would guide the state to conform would order specific performance or injunctive relief.
Thank you, Claudia. I think the network, Claudia's network is fluctuating. So thank you so much for that intervention. I would just like to briefly share 6 key points out of a lot of points that we made today in this webinar. Number 1, the need for us to promote awareness on ADR and BR related issues. 2, lessons from the BHR space on the use of arbitration under the Hague rules to assess effective remedies. Number 3, how do we hold corporations and violators responsible under bilateral and multilateral treaties through the adoption of the UNGP framework, the use of non-state and judicial remedies. Then 3, the importance in highlighting and promoting dispute avoidance against post-dispute resolution. The need for increasing creative ADR solutions to provide remedies to impacted communities and individuals. The issue of legitimacy, transparency, diversity, due process, as well as enforceability of arbitral agreements and awards in relation to BHRO disputes, and so many other points that have been said today. Because of our time, I'd like to first of all apologize to attendees because we have actually exceeded our time by 10 minutes. So I want to, at this junction, appreciate, first of all, my president and chairman, Professor Fabian Ajogu, for spending the whole time with us. Initially, he had said he was only going to spend some few minutes with us because he had a very busy schedule. So thank you so much for accommodating us, and Professor Olawiye as well, for being so helpful in the preparation stage of the webinar. I want to thank all the panelists, Claudia and Eke, for giving us a time today, as well as thank you so much to Tolulope Adewemi. Daniel Leader has actually gone out. Thank you, Daniel. He told us he had a meeting during the webinar. He had to actually move his meeting forward because of the webinar. Thank you, Florence Shako. Thank you, Napoleon, and thank you, Dr. Oyeni, for your time. We so much appreciate it. Please, we will be knocking at your doors again before November. You will hear from us because it's been very insightful and interactive section we've had today. We want to continue this conversation and be able to come up with some resolution that we will definitely share with some businesses as well as regulatory bodies in Nigeria on how really we can integrate, business as well as human rights issues in their policies. So thank you everyone for creating time to be with us today. Please be informed that the recording of the webinar will be posted on our YouTube channel. So you can go to our YouTube channel, our Twitter channels to get a hold of the recording. Once again, thank you so much on behalf of the Nigerian Institute of Chartered Arbitrators and our co-organizers, the International Law Association Nigerian branch. Thank you so much. United Nations Human Rights Special Procedures Group, thank you. United Nations Development Program, thank you so much for all your support. And we look forward to having you again next time. Thank you, and do have a wonderful day.
Thank you, Madam Registrar. Thank you so much.
Thank you very much.
Thank you,
Bye.
everyone. Thank
Bye.
you. Thank you, Florence. Thank you, Claudia.
Bye-bye. Thank you.
Everyone, thank you both. Thank you so much, everyone. Bye-bye. Thanks, Claudia. It's been nice having you.